and today we are going to be talking about probate. But first, let's just quickly introduce ourselves. Like I said, I'm Heidi Brown, and I'm proud to work at Osterhout and McKinney. I am a board-certified elder law attorney in the state of Florida. And I am also a member of the American Bar Association, and I am also a member of the elder law section of the Florida Bar, where I currently serve as a chair of their Medicaid committee.
Hi, I'm Amy McGarry. I am also board certified in elder law by the Florida Bar. I am licensed in Florida and Ohio as an attorney. My office is Amy McGarry Law Office, and we are in Cape Coral, Florida. I as well belong to the Florida Bar Elder Law Committee, as well as the Real Property and Probate section of the Florida Bar. I am also a board member of the Academy of Florida Elder Law Attorneys. So Heidi, shall we begin today about talking about probate?
Sure. So a lot of people wonder, well, what is probate? And probate is just a court proceeding where we distribute the assets belonging to somebody who has passed away. The court will first look to see if there is a valid last will and testament, which we'll go over in a little bit. The court will look to see who are the beneficiaries and whether there are any creditors, and also what the assets are. In Florida, the court may end up appointing a personal representative, which is what we call an executor in Florida. So we have two main types of probate. First is summary probate, and the second one is formal probate. So first, with summary probate, it's a shorter type of probate. It is only for estates that are smaller, meaning $75,000 or less, or for an estate where the decedent, or meaning the deceased person, has been dead for more than 2 years. With this summary probate, you do not have an executor or personal representative appointed. And this type of proceeding typically takes 3 to 4 months. The other type of probate that we have is something called formal probate. It can be for estates worth more than $75,000. or estates where we need a personal representative to act on behalf of the decedent. So one example might be a lawsuit. Let's say the decedent died in a horrific car accident. There may need to be a formal probate opened up so that a personal representative can file a lawsuit against the guilty party. A formal probate typically takes 6 to 12 months. Do you have anything you'd like to add about the types of probate?
Yeah, just to let everybody know, in Florida, we have exempt property that is not counted towards the $75,000 limit. And the two main pieces of exempt property in Florida, well, the biggest one is your homestead property. If your homestead is going to a family member or somebody in that family tree. You can even skip a family member like a child and go to a grandchild, and it is still, under most circumstances, going to be considered an exempt asset. If it will be an exempt asset, we're able to use that homestead as a zero value towards the court when doing a summary administration, so that we don't have to open up a formal probate for that. However, there are times, even with a where maybe the only asset is the homestead, that it may be beneficial to open up a formal probate, especially if there is a mortgage on the house and the mortgage company will not talk to the family to know what the balance is and how to pay it off. So those are rare times that we sometimes also, even if the asset is only homestead, have to open up a formal probate to be able to do that. Additionally, with a summary administration, it is very helpful that all the beneficiaries in the estate will consent and sign consents to the petition for summary administration so that they understand what is going on, and that we don't have to serve them by formal notice, and that once the court is ready to distribute those assets, it is much easier between the family, that if all family members know what's going on.
So you may wonder, well, how do I know if my loved one's estate actually needs to be probated? So in Florida, we only need to probate certain types of assets. And typically, we look to see how is the asset titled or owned, and whether there are any beneficiaries for that asset. So probate is normally only required if the asset was only in the name of the decedent, and there are no joint owners and no beneficiary designation. And it might work better if I give you a couple of examples. So for example, let's say Amy and I have a joint bank account and I pass away. Amy will automatically inherit all of the joint bank account per the terms of the joint bank account agreement. Or let's say, for example, I have life insurance and I've named Amy to be the beneficiary. If I pass away, she does not need to go to probate for that life insurance policy. She can call up the life insurance company and they'll send her a claim form in the mail, hopefully. Another type of asset that normally doesn't need a probate is a trust asset. So let's say I have my own revocable living trust, and I have opened up a bank account and I've titled it properly so that it is owned by my revocable living trust. When I pass away, that account will not need to be probated. Rather, it will be distributed according to the terms of my trust.
One thing that people want to make sure that they remember is that many times somebody will have a bank account that is just owned jointly with one of their children, yet their will states that their assets are to be divided per their assets are to be divided in equal shares, let's say to the three of their children. If that child is the sole joint owner on that account with their parent when mom or dad dies, that child for most times is going to be the only owner of that account, and under most circumstances does not have a legal obligation to share that with their siblings, even though the will says different. Because again, this is not a probate asset. Only probate assets have to be distributed per the terms of the will. So it is very important to make sure that when you're doing an estate plan, that you just not look at what your will says or your trust says, but that you're also looking at how all your assets are titled, as well as what those beneficiaries or co-ownership designations are.
There can be another time when we may need to file for probate, even if somebody's assets are all jointly titled or have beneficiaries. And that would be a case where the deceased person was a party either to an existing civil lawsuit or has the right to become a party or a plaintiff in a future civil lawsuit. For example, the wrongful death lawsuit. So let's say I pass away as a result of medical malpractice. Let's say a doctor made a huge error in my surgery and it caused me to pass away. Or I should say, no matter how my assets are titled, we will still need to file a probate for my estate to be able to file a medical malpractice lawsuit against the doctor and perhaps even the hospital. Another example would be if I was already a defendant in a civil lawsuit before I passed away. So let's say I hit somebody with my car and I'm a defendant, and then I later pass away. there may need to be a probate opened up for my estate so that the plaintiff could still have a lawsuit against my estate. So you may be wondering, well, what exactly is this last will and testament that you mentioned earlier? And basically, a last will and testament is just a document that states who do you want to inherit your assets after you pass away? How do you want them to be distributed? It can also state who do you want to be your personal representative or executor. In other words, who do you want to be in charge of your estate? So in Florida, we have certain requirements to make to make sure that the last will and testament is valid. One of the biggest ones is that the maker, which is called a testator, must have testamentary capacity and be over 18. And you may say, well, what exactly is testamentary capacity? Amy, would you like to fill us in?
They need to know what they own, not necessarily every asset that they own and every bank account and where they bank at, because maybe they haven't been doing that for years. Maybe their spouse was the one who's been paying the bills and that, but they need to know generally what they own, as well as who their family members are and who they would like to give the money to, and if they just know who their families are, and if they wanted to leave it to a non-family member, we do have to look at that to make sure, or only to one family member, that we don't have any undue influence going on as well.
So, and that's very important. I've had people come to me and say that their mother wants to change her will, but unfortunately she is suffering from advanced dementia and no longer believes that it's the current year, but rather 40 years ago, and believes that she's in a different state than Florida. Mm-hmm. In those cases, I'm very sorry, but we have to decline. We may be unable to prepare a new will for her, even if she honestly wants to change it. Another requirement in Florida is that the will must be in writing, and the testator has to sign the will at the end. So sometimes people will sign a will and then maybe they'll change their mind or decide to add something, and they'll add an extra page or paragraph below their signature. And unfortunately, that the paragraph that they've added will not work.
The other issue sometimes we have, Heidi, and I'm sure you have seen, is where people write on their will.
Yes.
After it's already been signed and notarized, and years later that they may go back and write on their will to make changes. That actually could void the entire will itself. And then we have no will. And we'll be talking about in the future here what happens if you die without a will. So that may be truly not the intent of what the person wanted.
Also, we have to sign the will in front of two witnesses, and the two witnesses have to sign or witness the document in front of the testator and each other. Now, we don't technically have to sign in front of a notary for the will to be valid, but if we don't want to have to later bring in witnesses to court to testify about the will and what it contained, we do need to have a self-proof affidavit that is notarized, and signed by the notary in order to avoid that contingency. So you may wonder, well, what happens if I die without a will? Or I've destroyed my will and I
or wrote all over it
and not prepared a new one. Well, then that's called intestacy. And in Florida, the Florida statutes will say who will inherit your assets. And it may not necessarily be who you want. Now, some people think that if you die without a will, that everything will go to the state. But that's not necessarily the case. A lot depends upon your family situation. So, as I said, the Florida law tells us who will inherit if you do not have a will. So, if you are married and you have no kids, then everything's going to go to your spouse. If you have kids and your spouse has the same kids, then once again, everything's going to go to your spouse. And I think most people would probably want everything to go to their spouse. But if you have more of a blended family where there are stepchildren involved, so for example, if you have kids, but they do not, or they are not the kids of your spouse, then your spouse only gets 50% and your kids get 50%. So that's more like the step family or blended family. And then if you have a kid who belongs also to your spouse, but the spouse has their own kids as well, then the spouse gets 50% and your kids get 50%. So it can get a little bit confusing when we have step families involved. If you're not married, then there's a whole nother list of priority. So if you happen to have kids, then they will each inherit an equal share of your estate. If you have no kids and you're not married, then everything will go to your parents. And if only one of them's alive, well, then it will all go to that one parent. If your parents have died before you, then everything's going to go to your siblings. And if your siblings have died before you, then we have to go half to your mother's family and half to your father's family, and then further and further down the line.
And just to let you know that if you did have kids but your children had predeceased you, or you, when it got down to the brother and sister line, if your brothers and sisters had predeceased you, their share would actually drop to their own children. It's if they don't have children that we're gonna you'd have to each complete each line to get down to the other. But this can include all the way, you know, as we're going all the way down. That you could actually get to stepkids, but it is a way down there to be able to do that. So,
and it's pretty rare that somebody's estate will go to the actual state of Florida, because most people in the U.S. have either first cousins or second cousins.
Yeah, it is a misconception that people think that if they die without a will, that the state of Florida is the first person to get their assets and that, or tax it on there and get a good portion of it, and that is just not true. The Florida law will dictate where it goes, but it actually takes quite a bit all the way down. And I can tell you, 25 years of practicing law, I've never had one. Have you ever had one, Heidi, where it's gone all the way to the state?
No, but we've had cases where we did not know much about the decedent, and we had to hire an heir search type company or a private investigator, and it became very expensive very quickly to try to find heirs who would inherit from this person. And that, of course, the estate ends up paying the fees for the heir search and the private investigators. So I think the good takeaway from this is, you know, you should have your last will and testament prepared ahead of time. And you should also, even though we've not mentioned this before, keep it in a safe place. You do not want to destroy it, because when it comes to written wills, the requirement is still to file for probate. You have to have the original. And if you cannot find the original, there is a way that you can petition to have a copy admitted, but it is extra work and may involve a court hearing and perhaps testimony. So you want to make sure you keep your original will safe. And that is our talk today about probate.
Well, we look forward to bringing you more topics, so keep watching and we'll have more topics to come.